to the Constitution. In other words, what I mean is that this act is emanating from the Constitution. And the reason why I raised that was saying that on the 3rd of November, you would know that the National Assembly met and they appointed this ad hoc committee. And of course, they appointed it in line with this act that I've just mentioned. And now, when they appointed the committee, it was a legislative responsibility, which is quite correct because that's their responsibility. But they appointed this ad hoc committee to do to do work that needs.
See that we will now be briefed by the Public Protector on Report 23 of 2013/2014, when governance and ethics fail. Public Protector will be, as with all the others, be afforded an opportunity to talk to the report, and if there are questions of clarity that we require from our side, we will afford members the opportunity to do that. And as with everybody else, we're going to be strict with time because, as I say, we have another witness after this. Can we start by Public Protector thanking you? Can we start by thanking you so much for making yourself available, and also indicate, without muddying the waters somewhat, you did indicate to us that you were available on the 1st and the 7th when we first made that our report. We subsequently, I think, changed it because of circumstances beyond our control. And, of course, it became the story in the newspaper. But, yes, I just wanted to confirm that, in fact, your original one said you are available on the 1st at after 4, if memory serves me, and the 7th after 4. So I thought, let's set that record straight so that all of us, so that it's not you speaking or us speaking or everybody speaking, but we acknowledge that that's what it was, and so that record is straight. It's the 7th, you are here, and that's probably what's most important, that we afford you an opportunity to brief us. I'm sure all the other matters that we had raised and spoke about doesn't need to be re-engaged now. I don't think so, unless you still think so, but we are ready to go. Public Protector, if you're ready to go. We'll hand it all over to you. It is 4 o'clock or just past 4, and if at the absolute latest, by about 4:45, you could be done with your side. If you need that much time, members will then ask questions of clarity, and we'll try and wrap it up, because it's really about us seeing the report on the same level. So around about 4:45, we'll start indicating that please wrap up if you go that far. And once again, thank you for making yourself available and for participating. Over to you, ma'am.
Thank you, Chairperson, and thank you to the members of the ad hoc committee. I'm with Ms. Nkosi. She's the compliance officer, manager compliance within my office. I will make a presentation. In fact, for the benefit of the committee, it will address the findings, the remedial action, and the status of that remedial action. And thereafter, I will deal with the chronology of events, our communication with the SABC to comply to the report, which I think was falling within the terms of reference of the committee. We investigated the allegations of maladministration, systemic corporate governance, failure, abuse of power, and the irregular appointment of Mr. Hlaudi Motsweneng by the SABC, which has been lodged in 2012 by the former senior executive of the public broadcaster. The investigation culminated in the issuing of the provisional report, which was titled The Blame Game, in December 2013, to which comments and responses were invited in terms of subsection 9 of the Public Protector Act from those implicated and against whom possible adverse findings were likely to be made. After receipt of those responses to the provisional report and consideration and the incorporation of such, a final report was produced, which is entitled When Governance Fail, When Governance and Ethics Fail, was issued in February 2014 on the 17th. The SABC board was directed to implement a number of remedial actions taken by the Public Protector. The presentation will cover the key findings made, the remedial action taken, the status of the remedial action, the SABC board's engagement with the Public Protector on the report. The finding on the appointment of Mr. Mutsoening as the acting COO was irregular. The remedial action to be taken then was the board to initiate appropriate disciplinary action against Mr. Mutsoening and Ms. Lulama Mokobo. This was partially implemented. Whilst the board did initiate a disciplinary action against Mr. Mutsoening, it only did this after a court application was instituted to compel them to do so. The process was also malicious or malicious compliance, as key witnesses were not called and important evidence was not produced. The second finding, Mr. Mutsoening committed fraud by stating in his application form that he had matric. This is improper and constitutes a dishonest act as envisaged in terms of Section 6, subsection 4, Roman figure 2 of the Public Protector Act. The minister to take urgent steps to fill the vacant position of the COO with a suitably qualified permanent incumbent. This was not implemented. Mr. Mutsoening was appointed by the board as the permanent COO. This was subsequently set aside by the court after the Democratic Alliance challenged the appointment. Number 3, the appointment of Mr. Sali Mutsoening and salary increments were irregular. The remedial action, the board recovers any fruitless and wasteful expenditure resulting from irregular salary increments. This was not implemented. Appointment of Ms. Gugu Duda and CFO was irregular. To take note of the findings against former Minister of Communication, Ms. Pule, this is for noting because no action is required. Mr. Mutsoening purged senior staff members, leading to the loss of millions of rands on unnecessary settlement for irregular terminations of contracts of employment. The remedial action was the board to issue a public apology to the complainants and former employees that suffered prejudice. This was never implemented. Mr. Mutsoening irregularly increased salaries of various staff members, leading to the salary bill increase of 29 million. This amounted to financial mismanagement and improper conduct and maladministration. The board, to ensure that human resource process on the creation of new post appointment and salary scales and progressions are reviewed. This was never implemented. The above findings are symptomatic of pathological corporate governance deficiencies at the SABC. The roles and relationship of the board and COO are defined, particularly in relation to the role of a relationship with the group CEO to avoid paralysis and premature exit of the group CEO. This was never implemented. The department and the Minister of Communication is unduly interfering in the affairs of the SABC, giving unlawful orders to the SABC board and staff. The Minister to institute disciplinary action against Mr. Temba Piri. This was never done. And on the chronological, chronicles of remedial action, what we've done as an office to follow up with the SABC board to implement our remedial action. I'll start with the first one. The Public Protector issued a provisional report, which I've dealt with, where that report was finally issued. The second one, the Public Protector received the responses to the provisional report, and the final report was produced and finalized. After the final report was issued, the Public Protector convened a meeting with the SABC board's chairperson, Ms. Shabalala, on the 14th of February to the findings and remedial actions to be taken in the final report by the new board. And then there was a final report which was issued on the 17th of February, 2014. 21st of February, there was a Mail and Guardian article published where the chairperson of the board was quoted as making statement that Mr. Motsweneng will be retained as the SABC employee, and the letter was signed by the SABC board's chairperson, Ms. E. Shabalala, where we then wrote a letter to the board to say, how can they make such a statement when we are still waiting for the response on the implementation of the remedial actions? The SABC board then appointed a firm of attorneys to respond to the Public Protector report. This resulted in the 97 pages of the legal advisory report by the Mchunu attorneys. And then that report was sent to the Public Protector. A further correspondence was received from the chairperson of the board. In the correspondence, the chairperson requested indulgence from the Public Protector to consider the findings and remedial action before implementation. And there was another correspondence which the board announced the appointment of Mr. Motsweneng as the permanent COO, and there was no prior communication from the board to the Minister refused to meet the Public Protector. As a result of this, a notice was issued to the minister, and the minister was subpoenaed to appear before the Public Protector, and then the minister then appeared before the Public Protector because the reason which was raised was that the matter was sub judice, but then the minister finally responded after the Public Protector reminded the minister about the provisions of Section 9 of the Public Protector Act, where if any decision taken by an individual which is can be regarded as contempt of the Public Protector actions. As a result of this, the Public Protector issued a subpoena. I think let's go to the next page. Then the Public Protector wrote to the minister in a letter dated 4 August, where the Public Protector advised on the institution's powers and directives to Minister Mutambi that just because of the matter is sub judice does not stop the Public Protector's office from looking into certain parts thereof. There was then a correspondence from the SABC board chairperson dated 22 August 2014. The response purports to be an implementation plan, because after we issue a report, we request the institution to prepare an implementation plan where they will detail how they will be implementing the remedial action. Following the Supreme Court of Appeal proceedings, the board considered that they will institute disciplinary proceedings against Mr. Motsweneng. The disciplinary inquiry was initiated on the 11th of November 2015 and was concluded on the 5th of December. They then prepared index folder as per request. In fact, they requested us to prepare an index folder for them to give them any evidence in our possession so that they can prepare for this disciplinary inquiry. But that was prepared, and we offered to give this to the pro forma prosecutor who requested the documents, but then that pro forma prosecutor was later replaced, and the meeting never took place, and the file is still with the office. They never collected the file, and the disciplinary proceedings went on. In conclusion, the SABC failed to inform the Public Protector of their compliance with the findings as well as their implementation of the remedial action taken in the final report, despite there being specific timelines in the report. The SABC had subsequently instituted disciplinary proceedings against the CFO, Ms. Gugu Duda, which resulted in her services being terminated. In what the board considers compliance with the Public Protector's remedial action, the board also filled the vacant position of the COO by appointing Mr. Motswening as the permanent incumbent. In November 2015, the SABC had also started disciplinary proceedings against Mr. Motswening, in which several key witnesses who are former employees were supposed to testify, but in the end, they were never called. The evidence file requested for and prepared by the Public Protector for disciplinary hearing is still lying in the investigator's office. It is important to know that disciplinary action hearing against Mr. Motswening, as directed by the Public Protector, was only initiated after the Democratic Alliance sought a court order to that effect. Prior to this, the board held the view that the Mchunu attorney's report, which exonerated Mr. Motswening, could be relied on in defiance of the remedial action taken by the Public Protector. The SABC, on the other hand, has decided to take the report when governance and ethics fail on review. This was 25 months after their submission of an implementation plan, and as indicated above, purportedly complying with the plan. This was also after implementing some of the remedial action taken in the report. The Public Protector has filed the record of evidence. The SABC has to file a supplementary affidavit before the Public Protector files an answering affidavit. Thank you, Chairperson.
Thank you so much, ma'am. That then, members, is where we started and where we are at now in terms of the implementation of, because I think that's what we were looking at, implementation of remedial actions of the report as laid out by Public Protector. Can I have an indication of members wanting to interact? Mr. Singh? Mr. Mukwena? I'm taking it down. Mr. Swartz, I'm sure you're standing in as an alternate for somebody, are you? Good. Just for the record, Mr. Swartz is an alternate so that you don't think that he's a gate crasher or something. Ms. Van Dam? Ms. Koza? Ms. Loliwe? Ms. Killian? Mr. Chauke? And Mr. Matlango. Can we then start with Mr. Singh?
Thank you, Chairperson, and thank you to the Public Protector. Public Protector, we realize that this report was concluded before you held office, but it's a report of the Office of the Public Protector. The big question is now from your side, quo vadis? Where to now? They've defied every single remedial action which constitutionally they are supposed to comply with, because the Court has ruled that remedial action is binding. What is your advice in this regard as a Public Protector, and what would your office do? Secondly, it took them 25 months on the last page to review this matter, if I understand you correctly. Is there a particular time period to call for a review of a Public Protector's report? Is there an upper limit and a lower limit, a time period? And lastly, a number of the remedial actions is supposed to be implemented by the board. Do you consider the one person standing as the board, quote unquote? Thank you.
Thank you very much, sir. Honorable Mukwena?
Thanks, Chair. Thank you, Public Protector. I think the report is self-explanatory. Thanks very much. I'm concerned that in the portfolio committee, in the communications portfolio committee, the SABC had come to the committee to say that they, in fact, had held a disciplinary inquiry, but it was an inquiry. It seemed to me, and I pointed it out to them, that there's a difference between implementation of remedial action and a whole new inquiry. And that they then went and opened an inquiry, for me, is undermining the office of the PP. And I wanted to also ask the question, what then is the, given that they've literally defied everything that your office has recommended, what then is the, what would be the next thing now from your office? Thanks.
Thank you very much, sir. Honorable Swartz.
Thank you, Chairperson, and thank you for allowing me. Public Protector, just to raise a number of issues, and we appreciate that this was your predecessor, but one of the most singular events that stands out was the letter by the Mqunu attorneys that sought to replace the remedial actions of the Public Protector. And I remember speaking about that in Parliament, saying it could never be so. And so there seems to be a singular lack of compliance with the remedial actions that were the binding findings by the Public Protector. And whilst you've been asked already where to from here, clearly there are different, on your slides 4 and 5, where you say not implemented, not implemented, not implemented, and these would require further action because there are different elements here. Now, we also appreciate that incorrectly the minister, and I'm sure that the chairperson, there'll be an opportunity to ask questions to the minister about her attitude to the Public Protector's report and the implementation of certain views, but the incorrect application of the sub judice rule and saying we're not complying and causing the then Public Protector to issue subpoenas, which again resulted in delays. The obvious question that has been put to you is about the review now that has been brought, and again, 25 months later, in my view, it would be out of time, totally out of time, and I think you could probably make a compelling argument for that. Where are the timeline for that? We understand that you've said that the record has been filed and that there's now going to be a supplementary affidavit. Would you, and I would strongly, when you first appeared before the Justice Committee, I strongly recommended it. Are you seeking a cost order against the applicant? Because that would be obviously dissuade persons from what appears to be vexatious litigation. And then lastly, the very telling information about the disciplinary action file that was not removed, that you made available and was not used, and the fact that the prosecutor was then replaced, and the comment about the almost I think the word is not properly, malicious compliance, as key witnesses were not called. I think that is a hugely insightful comment about the deficiencies in the disciplinary process. So whilst we appreciate that you will be filing papers to answer certain things, and you might have to be careful how you respond to us here, but would you then agree, in light of what you say there, that disciplinary process should not be considered to be compliance with the remedial action that was required by the Public Protector? Thank you, Chairperson.
Honourable Swartz, the rule was 2 questions per member, but because you just joined us now, we were sympathetic to you.
My apologies.
No.
My apologies.
Not at all. We should have.
You know, lawyers tend to ask a lot of questions.
I should have warned you beforehand. I'm just saying it because following members, can we go back and stick to the rule that we've been applying the whole morning? Public Protector, we will get a sense of how many questions, and we might ask you to respond, and then other members would follow, but we'll just get a sense. It's Van Dam, and then followed by Honourable Khoza, and then maybe we'll allow you to respond, and we'll take the other members thereafter. Honourable Van Dam.
Thanks, Chair. Short and sharp like I am. Joking. My question is also about follow through. Where to from here? I think it's mainly been the Democratic Alliance that has taken various aspects of this report to court. We have taken the fact that the disciplinary action was a sham to court. We're challenging the fact that they want to review this report, and we're actually expecting judgment on Monday on our court case to have Mr. Motswaneng permanently removed from the SABC. So my question is, as a public protector, which is what the same question that my colleague we were just talking about, how often do you follow through in terms of implementation action? I mean, you're here now. It's been 2 years since this report was last tabled. How often do you go to the people that the reports implicate, so the people who have been ordered to ensure that certain remedial action is implemented? How often do you go back to them and make sure that the action is implemented? And if not, at what stage do you say, so far and no further, X action will now be taken?
Honorable Khoza.
Thank you. You know, Chair, there is a narrative that we need to correct here. And I think it's important that as the African National Congress, we become very clear and we present this narrative in an unambiguous, in as clear a crystal way as possible. The truth of the matter is that we've taken a conscious decision that we want these state institutions to be cleaned up. And that is why we wanted to know from you, Madam Public Protector, whether you have engaged with the minister currently since taking office, probably raising the issues around the non-implementation of this and how we can take this matter forward. Because the thing is, we cannot allow the state of paralysis. And now I'm talking as the African National Congress. I'm not just speaking as Makosi Kozanjo, we're a member of the ad hoc committee. Because it's got to be clear that we are on top of this game. We really want to clean this thing up. It's giving us a very bad name. We have an interest as the ANC to see that these institutions are turned around.
Public Protector, before you get swallowed up in so many questions, I have noted Honorable Oliwe, Killian, Chauke, and Matlangu, but maybe I should allow you to respond to these, ma'am, and then we'll field the questions from the other 4 members.
Thank you, Chairperson. Thank you for the questions, honorable members. Mr. Honorable Singh, yes, we felt as well that they've defied all the remedial actions. As I've indicated that the matter is, I think I'll address Honorable Singh, Honorable Swart, on the issue of the delay, the 25 months which it has taken for the SABC board to take us on review, because their letter which they've written to the former public protector in September, the chairperson, he indicated that he was not happy with the utterances made by the former public protector, that they haven't implemented the remedial actions, and that Mr. Motswaneng shouldn't be part of the SABC. And he indicated that they've taken us on judicial review only because after the matter of the EFF versus the president, they didn't know that the remedial actions of the public protector are binding. Hence, they took it to some further other remedies. But then I think I agree with the House that, and what Honorable Khoza is also saying, that we cannot allow a situation where there are remedial action which the public protector has issued, and there are departments which are still not complying. I must say that the inquiry which has been taken as well, it was just a matter of compliance, because you choose and pick which remedial actions you are implementing. That's also further indication that it's not taking the office seriously, because if you have a challenge with one of the remedial action or you are not happy with all the remedial action, the best way is to, as quickly as possible, take us on judicial review. But then they chose to implement one, and after the court has intervened in that particular matter. But the next step, I think all honorable members have asked, is to make sure that we follow up on this judicial review matter. But again, after 25 months, it's for the court to, in fact, in our answering affidavit, we will also, in fact, we've reflected the abuse or the undermining of the powers of the public protector, because we've indicated, I mean, they've only done that after 24 months, and the disciplinary hearing was only done just as a matter of compliance. On the issue of the seeking personal court order, I think we will check, Honorable Swart, what we've indicated in our other, answering affidavit, and we will see whether we can proceed with that. The key challenge with the Office of the Public Protector is the financial resources, because we've only appointed the manager compliance in 2014, and she only started to follow up on remedial actions 2015. And I mean, she's just the only official who's dealing with that. And a lot of departments are still delaying to respond, because in a proper sense of things, it's for us to even take them to court to issue a court order to comply with our remedial actions. But then it's a question of resources within the office, which is one challenge, but then those issues are taken into consideration. The issue of, I think I've covered all honorable members, unless the manager can respond on how often do we follow through on the remedial actions. And Honorable Kosa, on engaging the minister, for now, I haven't engaged the minister, because the issue of the judicial review then made us to follow through on that particular process. But I must indicate that there are several other departments where the investigators are complaining, or I receive complaints that there's no compliance, where we will be engaging various executives of those departments to engage with them. But then I think as a last resort, we'll have to take the matter to court.
Thank you, members. If I may respond to the manner in which we follow up with the remedial action, if I can maybe give you a background. Previously, the follow-up of the remedial action was being done by the investigators before my time, and I think that on its own delayed and made us to have backlog, about following up of the remedial action. So this this particular case is one of the cases that actually started by being followed up by the investigator, who had, apart from following up, had pile of cases that he had to investigate. But under normal circumstances, after the report has been issued by the public protector, normally at the back of the report there is a time frame that the state organ need to follow to comply with. Normally we give them 30 days to send the implementation plan, and also we'll give them 30 days, another 30 days for the implementation report. But in this regard, yes, they did send the implementation plan, which for me, that implementation plan, it was the same as, malicious complying, because it had, it was just justifying, the issues, the concerns that were raised. So I think on two of the remedial action is when they indicated that, training, they will train the staff, they were intending to attend, other courses. Yeah, but normally, immediately after the lapse of the time frame in the report, we follow up, and also we write letters. We remind when we don't get anything from the institution. We also make phone calls, with that particular institution, and we liaise with executive managers, and not with the junior level staff members. So we try by all means. It's just that the other challenge is that before the recent judgment, which cleared the mandate of the public protector, the challenge was that the state organ would, under normal circumstances, would question the mandate of the public protector, or others will allege that they are not clear, about our mandate. But since the recent judgment, that has since changed. Yeah, but that's how we do, and we have lots of meetings. We find that we have so many meetings before the implementation, and some they don't even send the implementation plan. Some they will just implement right away. So that's how we do. And like my principal has indicated, we have issue about also resources, because I'm currently the only one, and I'm assisted by 2 interns who joined just recently. So we're still in a process of developing a fully fledged unit for following up. Thank you.
Thank you so much, Madam Public Protector. Let me just raise some that I think you've missed, and we'll take other members and you can add them, but members can add. There was one about your report indicates the board will do this, the board will do this, the board will do that. In light of the fact that there is no board, what does that mean? So that was the one. The second one was a letter from attorneys Nkuna. I'm not sure if you've covered it, but I think it was raised by Mr. Swartz. And then thirdly, the fact that the file that you prepared for the DC was not used. I suppose that could fall into the malicious compliance, but I thought those are the 3 that you might not have covered. But let us move straight on to Honorable Loliwe, and then she will be followed by Honorable Killian. Honorable Loliwe?
Chair, sorry. Will that question be answered later then?
Yes, they will be answered. I'm just asking her to take note of them.
Thanks, Chair. Chair, I think I'm covered. It's just to comment that when I look at this report, I'm also a bit worried, because if you look at almost everything, it dates back to 2014, but nothing else has been done to ensure that implementation is taking place. I think it goes back to that question which was saying, now that we are in this state, what next? What needs to be done? Because I don't think we can sit with a 2014 report in 2016 without indicators as to what is actually happening, other than the one which is mentioned about the judicial issue. Yeah, thank you.
Thank you very much. Honorable Killian.
Thank you, Chairperson, and thank you to the Public Protector for the report. Chair, I hope you will not rule me out of order, but I'm going to say that it is good to see a women team for a change here before us today. We actually had a composition of a completely different team when we had the SABC and executive here earlier today. Chairperson, just to come back to the issue, and I'm really very happy with the summary that was given. But if we go to the detail of the Public Protector report, there are some other issues, and I don't know if they should have been collapsed in the disciplinary hearing. But I understood that certain fruitless and wasteful expenditure had to be recovered from persons. Now, Chair, through the reading of the report, it was clear that some of the documents were initiated by the then acting COO. For instance, the salary progression, appointment salary progression positions held by some of the people in the senior management. And in fact, there was a suggestion that there should be disciplinary action against the previous group CEO, and then she resigned. But all in all, it still feels that even if we could tick all the boxes, you know, here it looks really bad because with the exception of one that was partially implemented, and may we say, from what we understand, it really is a very good description to say it is malicious compliance. It's malicious compliance. Because if we look at the list of the disciplinary matters that should have served before that disciplinary committee, there's no way that a person could have walked out of such a disciplinary hearing if it was a thorough one, unscathed, exonerated from all wrongdoing. So that is the one that is maliciously complied with. But if we look at the rest, the boxes indicate not implemented, not implemented. But even so, I don't think we see any commitment to ensure thorough governance processes and procedures becoming the norm. And it is really a matter of very serious concern. Now,
I'm sorry, Ma'am Killian, I don't want to be rude to any of you, but can we just get to the point before we make, I mean, the long statements? What are the questions that we're asking? I'm just worried that it has a ripple effect. I mean,
okay.
there should be questions that we're asking, and I'm not being unkind to anybody. I thought that was the decision we've taken. So if you could continue, ma'am, and just get to the point in terms of the questions that we'd want answered, and we take it from there. I've got 1, 2, 3, 4 more people that want to raise questions after Honorable Killian. Over to you, ma'am.
Okay, my question would be, is this a comprehensive list? Or is it important for the committee to scrutinize the balance? I mean, there's a category of findings, but for the rest, there are still some matters that needs further scrutiny. Would you say if we would comply to ensure implementation of the list that you presented, that as for the rest, the other issues we could relax on?
I'm sorry, I didn't want to appear to be putting anybody under pressure, but time is against me. Honorable Chauke, followed by Honorable Mahlangu.
No, Chair, my 2 points. The judicial review will have come from a decision taken by the authority, which is the board, to challenge the findings. Now, if Public Protector's Office then entertain the review issue that we are now dealing with the review, when you know very well that there is no authority at the SABC as we speak. The question I'm going to ask you is that, have you checked these decisions, how they were taken to challenge, to go to the judicial review? Have you looked at that? Have you satisfied yourself that it's something that can stand at court when it is presented, rather than spending time and having to allow a situation that is wrong to go to court and is going to be rejected after 2 or 3 months or 3 years? I'm saying that, have you looked at that process? Because there will be a resolution that has been taken by a board. The board will have looked at the report. And on top of that, again, as we close, my last question, Chair, is when you submit your report to the board, was it in Braille or it was just a normal font that we have here? It's very important, this question that I'm raising, Chair. Thank you.
Thank you very much, Honorable Mahlangu, followed by Honorable Mokoena, followed by Honorable Waters, and then we'll allow you to respond, ma'am. Those are going to be the last participants, unfortunately. Honorable Mahlangu.
Chair, 2 quick questions. But I think before I do that, it is fair that I should congratulate the Public Protector on her appointment, knowing that she comes from our village and I've never had an opportunity to do that. The first question is, I think what colleagues have raised. In case the applicant is the professor, from where we stand, he has no local stand, because he can't act without a decision. But if it's someone else, in this case, Mhlambe, Mtswening, it's something that I think that clarity is crucial, that we know who is doing it. But the second matter is something that I would have thought would have been a parallel process. There's a myriad of fraud actions which were found by the same report of the public protector. Are all these things subject to now the review? Because I would have thought in the intervening period, someone should have laid a criminal charge with the police or scope or whatever. Whatever those police people that are specialists, it's fine. I guess those are the two things, Chair, that I'd like to raise. Thank you.
I thank you very much, Honourable Mokoena.
Thanks, Chair. I'm done with the public protector. I think it's self-explanatory. My worry, Chair, is this issue of taking the public protector's decisions on review is becoming a problem now, and in particular, and I think we're going to see more of that. There was a time when, the public protector was just not recognized. Now, after the Constitutional Court, she's recognized, but we can take her decision on review. But in terms of the SABCs taking the public protector's remedial actions on review, I'm just wondering, at what stage of the board were we at the time that the decision to take the review action? Because I'm of the opinion that if it happened now, when the board had 4 members instead of 9, the department or government as a shareholder has a right to withdraw that decision. And it's just something that I think we need to look at. The second thing that I think we need to look at is the role of the minister, who seems to have made the investigation into this public protector's report almost impossible. That she was not available. Is she going to come in front of this committee so that we can? Because I think these are some of the things that we need to talk about: the role of the minister, the role of ICASA, the role of all these other surrounding bodies that could have contributed to the demise of this institution. Thanks, Chair.
Just before I go to Honourable Waters, so that you don't have to mark it, the Minister is indeed scheduled to come, so certain questions can be best placed in front of the Minister. So you don't have to take note of that one, ma'am, if you don't want to. Honourable Waters?
Chair, thank you, and to the Public Protector, thank you very much. I'm glad to hear the Minister is coming, Chair, because if you look at Remedial Action 8, the Minister was accountable there on slide 5. She had to institute disciplinary action against Mr. Temba Perry, and she's failed to do so. So she too is in contempt as much as the board, the then board. And I know the board, I think in February 2014, if I remember correctly, was a fully fledged board at that stage. It was only later that members started leaving. We need to find out from the Minister, and I'm horrified that the Minister has not at least done her part. I mean, she should be at the forefront of trying to get the SABC right and rectifying all the wrongs there. So I think, and I just want to know from the Public Protector, in your answering affidavit that you're going to be filing soon, are you including the Minister in that answering affidavit or not? Or is it just matters pertaining to the board? And then the last question, Chair, I hear the Public Protector's Office saying that they're under-resourced, they cannot follow up on remedial action all the time. And we've just heard there's the one lady in the office with 2 interns. What would it take financially, have you worked it out, to have a proper fledged office that could follow up on all reports to ensure that all remedial action is taken, and to also take the necessary legal steps, if needs be, to ensure that all your recommendations are adhered to. Thank you.
Public Protector.
Thank you, Chairperson. On the question of whether there is a board or not, I think that is a common fact that currently there's no board because there's no quorum. I think that was asked based on that in the previous questions. And I indicated that the SABC board, instead of implementing our remedial action, they went further to request the legal opinion, and they just sent us the Mkhunu legal opinion without engaging on each remedial action. And as the manager is saying that they were justifying all the remedial action. Instead of implementing, they were justifying why they cannot implement. And the file is still there because it was prepared for the very same reason, to say, here's the file, will assist the prosecutor or whoever will be presiding over the disciplinary hearing. So all those are actions which shows the way the report was never taken serious. And on the issue of judicial review and what next, I think I've indicated that the judicial review for now, it's for us to make sure that the process is fast-tracked. But I think Honorable Van Damme was saying there is a decision possibly on Monday that will also assist to check whether will that assist in some of the remedial action, because I think it includes some of our recommendations. But we will have to follow up on that. On the issue of Honorable Killian, the presentation has summarized, there is a detailed document I've sent to the committee. I think the committee should recognize the detailed narrative, because we've indicated all the findings, we've broken it down, and we've also indicated what was the response from the SABC, because there you will see that they were not implementing, they were just justifying what they will be doing. So I'll request that the honorable members consider that document, because it also includes the issue of fruitless and wasteful expenditure, because once they implement the remedial action, and I hope the Auditor General will be touching on that or has touched on the very same issue. So the presentation is not final regarding this detailed report, detailed presentation. Honorable Chauke, on the issue of the judicial review was lodged in May 2016. So can I be allowed to go back and check? And I think answering this together with Honorable Waters to say, let me check what was our answering affidavit, all the documentation, and who lodged the judicial review. Was it the professor, the board? Was it fully full complemented board or not? And then that one I will respond to the chairperson. I think we will do that by tomorrow. And then so then it will also ascertain whether the judicial review can stand in a court of law. The documents, we've been communicating with SABC with the normal documents. We never translated our documents on Braille, and the responses and the letters we received from the chairperson of the board or when we respond to the letters of the chairperson, we were not translating them. And Honorable Mahlangu, I think I've answered the question that we will check who lodged in May, because, and as well was the board fully a full complement. And the issues of fraud, I think we will just, we haven't opened a case, and the report was only sent to the board and the minister to act on them. I think there was an element of the file which got lost, especially the personal file of Mr. Mutswaning, where we had documentation which proved that he said he has a matric, whereas later of that file couldn't be found. So we'll also check whether we can find a way of checking whether there was any fraudulent activities which took place. On the issue of Honorable Mukwena,
Sorry,
I
Public
think
Protector, sorry. I was accusing these of not talking too much. I'm just being informed that you're too close to the mic and it might be distorting the transcriptions. Thank you, ma'am.
all right. Honorable Mukwena, on the role of the minister, I think I'm glad on the issue of saying, oh, I would love to be assured that I hope a lot of the executive or ministers take cognizance of the fact that you need to implement the remedial actions of the Public Protector. And as I indicated that going forward, we will try our means to engage as openly as possible and the cooperation from those departments or those ministries, because as soon as you cooperate and you give us full information and not tell the office that the matter is sub judice or you cannot, avail yourself, answer the question so that when the report is issued, it's a report which is implementable. But then I think going forward, we will encourage that be the working relationship. Because the minister, there is an official from, now the official is under Department of Telecommunication. I think if you go to the detailed report, and one of the minister's response was that that official is now with telecommunication. So, but the official is still an employee of government, and surely the minister can write a dear colleague letter to say, can you handle this particular official who violated or who did the following? So those are the issues which I hope the minister will also take forward. The Office of the Compliance, Honorable Waters, we beefing up the legal services section, which will also work closely with the compliance manager, because then it's an issue of compliance, not only for remedial action, but then it's compliance of the institution towards legislative provisions. But then those are the areas where we'll have to reprioritize within our budget, on the limited budget, to see how we can beef up the compliance section. But then we will be appointing a senior manager legal services as well, which will be a resource we'll be utilizing to follow up on this. And we will also find a way of making sure that whatever resources we are having on those key remedial actions or reports, we then institute, in fact, we take the various departments to court to enforce our remedial actions. Thank you, Chairperson.
I thank you very much on behalf of the committee, Madam Public Protector. I think we have sufficient. Public Protector will give us the other stuff that she's made commitment in writing, and as usual, we'll share it with everybody else. So thank you, Public Protector. I thought you were going to take advantage of the gap that somebody gave you to cry for additional budget. You didn't do that, but we'll make that opportunity available to you some other time as well. Thanks so much. Honourable members, just before we continue, you recall that we had lined up former board member Ronnie Lubisi to be the next. We've just had word that unfortunately Professor Bongani Kumalo is not very ill, but he's ill, he can't make it tomorrow. So with lots of gratitude, Ronnie Lubisi has agreed that he will then do his tomorrow, because otherwise we'd have one less, meaning that the proceedings for today are done. And tomorrow the proceedings will be as follows. Cindy is going to help me go along. On Thursday, we are going to have at 9:30 Mavuso, 11:30 Lulama, after Lulama Oh no, maybe because Ronnie Lubisi has been so kind. Maybe we'll make you first so that you can be released. Lulama has been confirmed. We'll ask Mavuso to move to the 2 o'clock slot, and then we've got the professor at 4 o'clock. So we've got 4 witnesses for tomorrow. I beg your pardon? Okay. We are suggesting for tomorrow that Ronnie Lubisi, who would have been now at 6, does 9:30 tomorrow so that he can be released. 11:30 will be Ms. Lulama Mokhoba, followed round about 2 o'clock by Mavuso, who is based in Cape Town, and then at 4 o'clock, we have got the professor. So those will be the 4 people for tomorrow. And tomorrow we'll give you the lineup for the next day. All right. We'll distribute an updated program after this meeting as well. But that is more or less the lineup. Thank you very much, Public Protector. Thank you very much to all our guests and also to members of Parliament. Can we be here 9:30 tomorrow morning in the same venue? Meeting has adjourned. But can members of the committee just remain for 1 second?